the governor in the present case. The petitioners have urged that the governor was not justified in reaching the conclusion that he did on the basis of the resolution dated 21 June 2022 because, 1, the 34 MLAs belonging to the Shiv Sena did not express their intention to exit the Mahavikas Aghadi government, and 2, the MLAs who signed the resolution constituted a faction of the SSLP. Although the resolution dated 21 June 2022 specifies that some MLAs of the SSLP were dissatisfied with the functioning of the MVA government, it does not record their intention to withdraw support from the government. Among the 34 MLAs who signed the resolution dated 28 June 2022, a few were also ministers in the government. On the basis of this resolution, the governor concluded that a majority of the Shiv Sena MLAs have given a clear indication that they intend to exit from the Mahavikas Aghadi government. The assembly was not in session when Mr. Fadnavis and 7 independent MLAs wrote to the governor. However, there was no attempt made by the members of the opposition parties to issue a notice for a no-confidence motion against the incumbent government. The governor had no objective material on the basis of which he could doubt the confidence of the incumbent government. The resolution on which the governor relied did not contain any indication that the MLAs wished to exit from the MVA government. The communication expressing discontent on the part of some MLAs is not sufficient for the governor to call for a floor test. The governor ought to apply his mind to the communication or any other material before him to assess whether the government seemed to have lost the confidence of the House.
India has read out the conclusion, some big takeaways. Let's open this up. Siddharth Thalia joining us. Harish Nair, our legal editor who's in the courtroom, will be live with us shortly. The Nabam Rabia case has been referred to a larger 7-judge bench. The Speaker will now decide the disqualification within a time frame that has been decided, or within a reasonable time frame, as the Chief Justice of India said. The primacy of political party over the legislature party has been underlined by the 5-judge constitution bench in this case, and more importantly, the CJI said that we can't quash Uddhav's resignation because as Chief Minister he resigned before the floor test and the resignation was voluntarily. Siddharth.
Absolutely, Pranesh. So that's the biggest takeaway, that the Supreme Court is not in a position right now to restore status quo ante. What is status quo ante? Uddhav Thackeray as Chief Minister. So the Supreme Court basically upholding status quo. Eknath Shinde will remain as the Chief Minister of Maharashtra and his government will continue to function. The Supreme Court clearly saying that had Uddhav Thackeray not resigned, had he not submitted his resignation, then perhaps the court could have gone into the possibility of a reinstatement, but that situation simply does not arise because he submitted his resignation. Very importantly, the Supreme Court, while criticizing the governor on multiple counts, Pranesh, and we'll get into the details, also said that once Uddhav Thackeray had submitted his resignation, then the governor was duty bound to actually invite Eknath Shinde's faction to come and form the government in Maharashtra, because clearly with the resignation of Uddhav Thackeray there would be a political vacuum, so to speak, in the state. So the governor would there have been duty bound to invite Eknath Shinde to form the government. But the biggest takeaway is Eknath Shinde's government survives, as does his coalition with Devendra Fadnavis. The Supreme Court not in any position to restore Uddhav Thackeray or his faction at the helm of affairs in the state of Maharashtra. What the Supreme Court did criticize the governor for was the fact that he interfered in a matter of disagreement within the Shiv Sena, because Eknath Shinde and his faction simply did not suggest at any point of time that they're going to quit the Shiv Sena party, that they are the true claimants of the Shiv Sena and the legacy of Bal Thackeray is what they claimed. They never said that they resign as Shiv Sena members. So in such a situation, could Bhagat Singh Koshyari, the governor, have actually interfered to arrive at a conclusion that the party has split and that Uddhav Thackeray's government no longer enjoys the confidence of the legislators? So that was a mistake and a move that the Supreme Court has actually criticized.
We have the first reaction.